Since 1988, this is really fun. Elizabeth has been a licensed landscape architect, which is kind of a fun thing. So, and prior to practicing law, she was producing landscape architectural plans for places like Disney theme parks and 5-star Ritz-Carlton and Marriott hotels throughout the world. So we are super blessed to have her. She is an amazing resource and hope you guys get a lot out of this. I know you will. So, all right, go ahead.
As soon as you have a child who has a diagnosis of autism, then you need to consider living trust, special needs trust, and also conservatorship at some point. So what is the we'll just start with the special needs trust part. And you may ask yourself, well, does my child need a special needs trust? So the threshold question is, can they manage their affairs, their finances? Can they make medical decisions for themselves and things like that? So if they cannot resist fraud and undue influence, most likely, as soon as you have the diagnosis, it's a good idea to look at a special needs trust. Because even people who are very high functioning on the autism spectrum who may not be appropriate persons to conserve will still need a special needs trust because they're just concrete thinkers. They're not able to resist fraud and undue influence. So what happens with the special needs trust? What happens is that in your estate planning documents, your will or your living trust, the special needs trust inherits from you instead. So if they're not able to do these things, then you need a special needs trust, which is the case with most persons who have the diagnosis. Just because predators are amazingly good at stealing from people and just leaving people penniless. And so it's really just to protect them first and foremost from predators. You don't want your child just living off means tested public benefits, which is $600 or $700 a month, and not what, right now you probably can't buy enough food to feed one person for that whole SSI payment. So what happens with the special needs trust? So these are the reasons, next slide, the reasons that you would set one up is that you would want it originally was to preserve means tested public benefits. So you need it as soon as you have a diagnosis. So the next slide. Thank you. So means tested public benefits include supplemental security income, that's SSI, and Medi-Cal in California. So I'm only a licensed attorney in California, so I can only give advice to people and I represent people in California. So just that's a caveat I should have said in the beginning. But anyway, that really was the driver for establishing them once they were authorized by federal law. And special needs trusts haven't really been around that long. So they've been only authorized by federal law in less time than I've been married to my husband. So 32 years, this year. So a lot of grandparents have never heard of special needs trusts. A lot of attorneys don't know how to do them correctly. And even the software drafters that do produce a maybe 13-page trusts are not correct. They're all going to court. So there's a lot of things that have to be in those trusts. But the main driver was to preserve their SSI, preserve their Medicaid or Medi-Cal. So if you have a child and you're leaving them half of your inheritance and you have 2 children, half of it is going to the child with autism, you can leave it to a special needs trust instead. And then your child never takes a name, they never inherit a name, that money's not theirs. If you don't do that, there are some pretty serious consequences. So next slide. Like I said, without a special needs trust in place, predators and creditors can pretty easily attack a child with autism and all the money's gone. And then they live the rest of their life, if they have any siblings or other family members, trying to have them support them or just live off means tested public benefits, which is very little money. It's 2/3 of poverty level. So it's a pretty serious thing. And that's what none of us would want for our child. So next slide. So what happens again is that the child, if you don't set up a special needs trust, then your child will inherit from you directly. That's what the law states. Once both parents die, your assets are divided equally among your children. So then if your child inherits directly, then they won't qualify for any of their means tested public benefits. Usually because they now have lost Medi-Cal, their inheritance, no matter what it is anecdotally in my practice, it's exhausted within 5 years. And I have clients who have had a child go in the hospital, and it was a $300,000 hospital bill in 1 week. So it's easy to go through a lot of money sometimes when you have medical issues and you don't qualify for insurance. Insurance is very, very expensive. And then, you can't get insurance. And so the money just gets eaten up on medical expenses. And then they are just left off, living off means tested public benefits. So then next slide. Thank you, Eric. He's my slide master. Okay. So, having a special needs trust is part of what's called an estate plan. So having a will, having a living trust. So can you die without an estate plan? What do you think? How about you, Eric and Kristen? So most people say, everyone says, yeah, you can die without one. Okay, Kurt is very, very wise. He's responding no. So you cannot die without an estate plan, because if you don't set one up during your lifetimes, the state has one waiting for you. And that's what probate court is, the laws of succession and the probate code. And that's what dictates happens to your assets after your death. The problem is, you may have multiple children, and you don't want your child with autism to take a name either way. But if you have multiple children, you may give unequally to those children. You might have a child that will go to Harvard, and then you have a child who's severely impacted by special needs, and you might leave more of your estate to that child. Well, according to the law, all of your children would take equally, but they would take a name unless an attorney represented your child and had that money put into a first party special needs trust. And we'll talk about those later. It's not what you want. So that's not a good option. You can't die without one. So you either set one up during your lifetime that supersedes what the law states, or you let the courts and the law apply that. The courts apply that law, and that's what will happen. So next slide. Thank you. Okay, so what about going to probate court? Is that something that you want to do, not want to do? Probate court is very expensive. It's very time consuming. So if you have more than $166,250 in countable assets at the time of the surviving spouse's death, if you're married, or if you're a single person, your death, then your estate will go to probate. So what is not counted? Life insurance, retirement plans, and anything that you'd license at the DMV. So you can have a $200,000 RV that won't cause probate because you license it at the DMV. But what's counted is your real property. So that's anything you hold a deed to. So your house, condo, townhouse, land, bank accounts, and non-retirement investments. So it's very expensive because the probate court costs are assigned based on, or assessed, I guess, based on the gross value of your property. So if you have, right now, if you have a house in Southern California, it's worth a lot of money, most likely. So, say you have a $1 million home, there were like condos in Oceanside that were going for $1 million just, 6 months ago. It's crazy. No view, parking lot view. But the $1 million assessment, the fee would be based on the $1 million, not if you had a $900,000 mortgage against that, or $500,000 mortgage. So you're paying fees based on your gross assets. And then they would pay the attorney that represented you, a personal representative, and any other court fees and costs that were involved. So it's very expensive. And that's all money that can go to your child instead, and should. You can easily, bypass probate court. It's not free, but it's a way better number. So next slide, please. So if you have more than $166,250 in countable assets, how can you avoid probate? Anybody have any idea? What happened to Kurt? You can avoid it with a living trust. So a living trust holds title to your assets. So anything that would cause probate is now not in your personal names, it's in the name of your living trust. So say it's in the Jack and Ruby Smith Living Trust. And so all your assets are titled in that by retitling your deed to your property, retitling your bank accounts, retitling your non-retirement investment accounts. And that cuts off the desire for probate, because you don't have anything in your names that would cause probate. And then the state law, the probate code wouldn't apply. You could do whatever you want now with your assets as far as distribution, and distribute, whatever percentage you want directly to that special needs trust instead. And I did notice, like, there are lots of people who have more than one child. You can put up to 3 children, 3 beneficiaries of one special needs trust. So they don't have to each have their own if you set up a third-party special needs trust. So a third party is set up before your death by you or you and your spouse, and then it works in conjunction with a living trust to avoid probate. Okay, so next slide. Thank you. So it names as a beneficiary the special needs trust. The child never inherits directly, and then all the money in the special needs trust is not counted toward their means tested public benefits. So rather than the other scenario where they inherit, they lose all their public benefits, they can't get insurance based on their diagnosis lots of times, or it's very expensive. The good scenario is that all the money that you leave them goes to the special needs trust. It's not counted at all. It's not under their name, it's not under their social security number, and it's not under their control. But the special needs trust has to be specifically drafted. And then your inheritance will be there for hopefully a long time during their lifetimes. Okay, next slide. Thank you. Okay, if you have a child who's under the age of 18, then you really need to have a nomination of guardian agreement. And what happens? So a lot of people have a will, and inside the will, they have one paragraph that says, I nominate my sister Susan to be guardian of my 2 children, if I'm incapacitated, if I die. The thing is, your will's not effective until you die. But that little paragraph is only a recommendation to the court. It's not actually a separate agreement that gives someone power. You may be in an accident and be incapacitated. You may have a brain injury. You may have lots of things happen. But if you don't set up a special needs trust before that incapacity or before your death, then the state is the default guardian. And nobody wants that. That means that the state can come in and they can seize your children, put them in foster care, not necessarily with any of the therapies, foods, clothing, program, or anything else they need in their life. And so to supersede that, you just need a nomination of guardian agreement. So it's not only effective when you die, it's also effective if you're incapacitated. And so the person who's named immediately has power over your child or children until they turn 18. Once someone is 18, they're a legal adult, and then the guardians would not have any more powers over them. But it's a very inexpensive document. It's not related to, it's not dependent on, creating any other document. And, it's, couple $100 or something, so it's definitely worth having that peace of mind. If you have a child who's under the age of 18, have a nomination of guardian agreement for them. Until they're 18, you are their legal guardians. So if you're alive and you have capacity, you don't need it, but you need it if something happens to you. And the only thing I can tell you is that any person, anytime, for any reason. And that's the sad reality of life. Especially we've all lost loved ones, family members, friends during COVID. But, it's a 38-year-old dropping dead now, and the 95-year-old still alive, unfortunately. So I have had one of the healthiest persons I ever had as a client get killed on a bike. And, somebody who smokes a lot still alive, so it's really not depending on anything. It's whatever, it's your time to go. So next slide, please. Thank you. Okay, so you do, when you get a living trust or you get estate planning documents, you really need comprehensive documents if you have a child with special needs. So you need a living trust, you need certification of that trust. You still have a will even when you have a living trust, because your will deals with your tangible personal property. And then if you have a trust, you have a pour over will, it pours over everything else into your living trust. You really need a durable power of attorney. Every adult needs a power of attorney. Once you are incapacitated, you can't create this document, but someone could act for you. Someone could act while you're incapacitated to bring an asset into the name of your trust if it looked like you were going to pass away, or they could just act for you if you were incapacitated. Without a durable power of attorney, then that person has to go to court to get the power to do that. So I'll just tell you a quick story about one lady. She called me. She and her mother were both, on title to her home, and her mother was kind of losing capacity. So she wanted to. Her mother agreed to take her name off, and she wanted to help pay her mother's bills and things like that. So she went to Staples. She got a $6 durable power of attorney. And then her mother had some capacity. She had the capacity to sign the durable power of attorney. After that, she lost capacity, and she is in a lockdown facility now. She's just no capacity at all, and declared incapacitated by doctors. So the daughter tried to pay her mother's bills, and most of her money, she had sold her house, was sitting in a Charles Schwab account. And so Charles Schwab pushed back and said, you don't have the power to access this account with this power of attorney. So she sent it to me, and I reviewed it, and I said, they're right. You don't have that power listed in this durable power of attorney. And so she had to go to court and get conservatorship over her mother's estate, with accountings due every single year and representation at court. And they're not accountings like, this is my Excel spreadsheet accounting. It's in the format that the court requires. It's a lot of documentation. It can be, an inch and a half in documentation for a couple of years, and attachments and everything. And that costs about $6,000. So she has to do that every single year for the rest of her mother's life. And if she had called me rather than gone to Staples, that document is only $250. So it's really, really important that you contract or hire someone who uses very good estate planning software. Like in my practice, I buy it every single year. And so it's always current, and it's very good software. It's not something that is 13 pages or 5 pages, So anyway, that's unfortunate. You really, if you want to avoid probate, you're looking at a fraction of the cost to set up the documents. It's not free, but either way, you will pay for that, out of your money. So that's the thing. Then get a nomination of guardian agreement while you have a minor child. It will give you peace of mind. And I had to do these for my own children, and I prepare them every week for people. But when I had to change it and update it for my son, because our older son was old enough to be his guardian, I cried. I mean, it's a really hard reality when you think of that happening, And then you need a declaration of intent regarding your schedule of assets, your assets typed up, tangible personal property agreement. Most people have $166,000 worth of stuff in their house, So that basically states all of these things in my home that would add up to cause probate I'm now holding in the name of the trust. And then you should have your deeds prepared correctly by an attorney. If something happens and your deed's not correct, then it's a cloud on title, and it takes a lot of work to clear up that cloud, to remove that problem. And then you should have grandparents provisions. I created these and I give them to all my clients, but that just, it's comprehensive planning. So most of our children have grandparents that are still alive, and they love them. And especially when a child has special needs, grandparents really want to help provide for that child. So they'll leave something to Johnny, but Johnny's, he can't take a name. So grandma hasn't heard about a special needs trust yet. You've already set one up. These are the provisions that their attorney can use so that their document leaves directly to your special needs trust rather than your child inheriting directly. The other thing is you have to remember that just the law about probate and everything else. So if your parents don't have an estate, you will take. If you don't survive your parents, your child's now taking. Also, in your living trust, you may think, well, my mom's leaving everything to me, so it's not an issue. But just like the man on the bike, just like the 42-year-old attorney who dropped dead of a brain aneurysm, I'm at the funeral and the grandparents are alive and the child with autism is alive and the parent has died. And that child is now taking everything the dad was taking. So it goes straight down usually, even when people draft documents, which is pretty much what the law states, but most people give everything to their children and maybe some charities off the top, and then it's equally divided among their children. So I'm not sure what that person's asking. Take a name. Anyway, so next slide, please.
Okay, my question is, you continue to say that person won't take a name, and we don't know what you mean.
Oh, in name. Yeah, I'm sorry. So you don't, say your son's child's name is Jeff Murphy. So you don't want Jeff to take in name. Sorry. So that means that grandma's documents state, it goes to Mary, my daughter Mary. If Mary doesn't survive, it goes equally divided among his children. Well, if it says Jeff's name in there or not, he will inherit his mother's share if his mother doesn't survive, her mother. So it just means you really don't want your child to take anything in their name. You want it all to go to your special needs trust instead. So sorry, hopefully that's clear. And then regarding the special needs trust, you can set up a third-party special needs trust. I don't have as much time to go into this because it's a dual subject presentation, but this third-party special needs trust is critical because if you don't set up a special needs trust during your lifetimes, your child may have one in court, like I stated, or if they inherit directly from someone, you can put it into a special needs trust. But those in court or they inherited directly are first party special needs trusts because now they inherited, it's their money. So it has to, in order for them not to lose all their means tested public benefits, it has to immediately be put into a first party special needs trust. The reason you don't want a first party special needs trust in court or outside court if they inherited, or if they have a big lawsuit, you have to do it that way. But first party special needs trusts have to have payback provisions. So payback provisions mean that when the beneficiary dies someday, so someday when your child passes away, the government comes in a payback provision scenario, and they just wipe it out. They pay themselves back for all Medi-Cal supplied to the child during their lifetimes. So usually they just exhaust whatever's money is in there. But if you have a third-party special needs trust set up during your lifetimes, so you set up a living trust, it leaves directly to a third-party special needs trust, they don't have to have payback provisions. They also don't have to have any of the other constraints that a first-party special needs trust has to have. So first-party special needs trust can only pay for anything the government doesn't pay for. So right now, food, how much is food 1 month for your child? Isn't that already in excess of that whole SSI $600 or $700 a month? it isn't my house anyway. So, if you have a child on SSI and that payment is supposed to be for food and shelter, then the trustee of a first party special needs trust cannot pay for an apartment, home, or anywhere for your child to live or any of their food. So isn't that that's really a horrible detriment to a first party special needs trust. They can pay for, zoo passes and lotion and shampoos and things like that. But the reality is that food and shelter are your two biggest needs in life, So if you set up your own living trust, you set up your own third party special needs trust, they do not have to have payback provisions. They can pay for anything that the child needs that's legal. And they aren't restricted in their investments. Like a first party special needs trust is very, very restricted. And if it's in court, a first party special needs trust has to have, just like the lady didn't have the durable power of attorney, they have to have accountings every other year. So still $6,000 every other year for the rest of your child's life to give an accounting of every penny in that special needs trust. So it's exponentially so much more to risk, having them inherit through probate. And they're so restricted that it really affects the entire quality of their life, because they can't pay for food and shelter. And you want your child to be on SSI because that's automatic qualification for Medi-Cal. So, you know what I mean? You can't really say, oh, I don't want that, so I don't need a first party. But either way, in probate court, you would have to have a first party. Or if your child's in a car accident, because it's their damages that have to be put into the trust. So it's their money, and it would have to be a first party special needs trust. So, but an attorney who does the special needs trust part of it does all of this on this slide. You need all these things. You may or may not need an EIN number yet, but eventually it's easy to get one. But you need a special needs trust. I'll just pause there real quickly to state that the software I use is very, very good. Only attorneys can buy it. It's very expensive, but and it updates now constantly. So it's very good. But even those attorneys don't know how to draft a special needs trust. So when I started drafting them 20 years ago, now it's 21. It was in 2000. 2002. Sorry. So I was one of 3 attorneys that were on the internet that had a website for a special needs trust. 3 attorneys, and I thought I knew one lady in LA, and I knew of 2 people in San Diego, and they were very good. They did very good work. But now, the list of people who really understand this topic remain a pretty small list, because the software will provide a special needs trust that I buy that's very good on all the other documents, but it's about 13 pages, and it does not have what the Social Security Administration requires. It won't stand up to Social Security Administration scrutiny, and so they'll all be converted to first party special needs trusts. And so if you want to call around and try to figure out, oh, this person, do they really know what they're talking about? You can ask them a couple questions. Sometimes people tell me that they just get like the deer in the headlights look, because they really don't know how to do it. They're just clicking that box on the software. And those are really going to impact families, because, it really does make me mad, because they are going to go to court, and they're going to be converted to first party special needs trust because they don't have the required provisions. So one by the software is 3 pages inside a living trust, or about 13 pages outside the trust by itself. Or if you have an attorney who really knows how to do them, they're 40 to 60 pages. So, and you need all these other documents with them, so just my memorandum that explains how do you administer this, how do you do this, the surrounding topics, like when was the federal law passed that authorized special needs trusts and things like that, what's counted as resources and assets by the by the beneficiary, what's excluded, what's not counted as their assets that they can own, all those other issues. is about 19 pages. So it's just my memo is longer than most people's special needs trust if they don't know how to do it. So I'm not trying to plug myself. I'm just trying to tell you that it's very important to end up with an attorney who knows how to do this, because the consequences are the quality of your child's life, the rest of their life. Okay, next slide, please. Thank you. So now we're on to conservatorship. Next slide, please. Okay, so what happens at age 18 on your child's 18th birthday? They can do any of these things. You lose all legal rights that you have, which our parental legal rights have really been slipping down a horrible slope, in the last 10 years. But anyway, what we have, they're gone 1 minute after their 18th birthday. So your child can move anywhere. They can make all their own medical decisions and everything else. So and they can vote in the military. Okay, and then next slide, please. So under the age of 18, again, under the age of 18, even if the child's neurotypical, they're considered incapacitated because they're a minor. So then parents have also legal rights that we have over them unless a court determines otherwise, because the child has to be removed from the parent's home or something like that. Then once the child turns 18, you lose all legal rights over them unless you seek conservatorship. So guardianship, conservatorship is a little confusing. And then again, during the age of 18, you can give, if you're the parents, you can give all legal rights to another person or persons, or a list of people in a row. If this person can't serve, then the next person, et cetera. So that, they have all the legal rights you have. And that's a 6-page document. That's another, like I said, very inexpensive document. And nobody goes to court. You don't have to go spend $4 or $5 or $6 grand to go to court. That they just use that 6-page document and they have all legal rights over your child. Once your child turns 18, nobody can have a written agreement. They have all those rights themselves. So what the court does is that the court takes the rights from the person, the new adult who is incapacitated because maybe there are special needs, and gives it to the conservators, which are usually the parents or some other family member. So like I stated earlier, HIPAA is a big driver in conservatorship now. It used to be to qualify for means tested public benefits. The parents would seek conservatorship, and for other reasons. But now it's because, when I was growing up, we had a doctor for 30 years. We had a family doctor. And when he retired, we got another doctor for 30 years. But doctors, for the most part, work for large corporations now, just for liability probably reasons and things like that. And so the corporations would require them to be HIPAA compliant. And I have had, my clients with a child with special needs in the hospital right when they were turning 18. And the doctors told them, on Thursday, you will not be able to make any decisions for your child. So fortunately for that family, we had already obtained conservatorship, so they were able to produce the letters and have the right to make medical decisions for him. But yeah, unless you have conservatorship and gain that right, you can't really do any of that after the age of 18. Okay, next slide. Thank you, Eric. Okay, so the threshold question for conservatorship is pretty similar to the threshold for special needs trust. So can they do any of these things? Can they decide where they're going to live, make their own medical decisions, make a good marriage decision, and things like that, and resist fraud and undue influence. So if they can do all those things, or they're pretty high functioning, conservatorship is not appropriate for every person with autism, and that's for sure. So there are persons on the spectrum who should just have, they can sign a durable power of attorney and a healthcare directive and give the parents those powers to help them make decisions. But you can't take that right away from anybody with a written agreement. So if they said, I don't want that surgery, then the doctor can't do the surgery. So if your child, you know, if you're kind of on the fence, do they need this or not? Sometimes it's best to go the least restrictive way first. Try the powers of attorney. If they don't work, then you can go back and apply for conservatorship. But if you know, based on their the severity of the autism that they can't do any of that, then you definitely need to apply for probate conservatorship. Okay, next slide. And when would you do that? You know, these are what I just talked about. When would you start that conservatorship process? I would find your attorney 6 months before at least 6 to 8 months before their 18th birthday. You can, in San Diego County anyway, get a hearing in about 60 days. And there are notice requirements for giving notice to first the child, the regional center, and the court investigator, if that's the case. So you're not going to get in next week for your hearing. So you need to start early, find your attorney. If you want to be represented by an attorney, you don't have to hire an attorney to do this. The conservatorships are not done all on pleading paper like they would have been 25 years ago. Now they're all on judicial council forms, but they're not layman friendly. they're barely attorney friendly, let me tell you that. And they're constantly, they get updated, and without notice. And then the clerks want them a certain way. So you have to understand the probate code to answer some of the questions, like, are you seeking powers under this probate code section or this probate code section? So, you'd have to look all that up and everything. But they do have clinics. You can go down to the courthouse and they'll have a clinic, or they'll give you the packet, and there's some help. It's very hard for people to do it. It's, efficiently. If you can't, hire an attorney, then you are looking at probably lots of trips to the courthouse, but you can do it. It's just going to be a lot of times and taking a lot of time, because if you get to the hearing and you haven't solved all the problems, that's called curing all the defects, then the court can't make a decision. You have to have everything complete, everything correct, everything submitted before they can make a ruling. And so they will just send the petitioners back out, and your hearing is not next Tuesday or Thursday, it's 3 months from now. So the reason that I tell people, start at least 8 months beforehand is it might take your attorney a month to get your documents done and have you sign them and then file them. And then you have 2 to 3 months before your first hearing. And then if it gets continued, that's another 3 months. So what are the reasons that it may be continued? It may be continued if your attorney made a mistake. It may also be continued because the regional center didn't supply their report on time, or the court-appointed attorney didn't complete their report. So it's very rare that a court-appointed attorney would not complete their report, because they don't get paid unless the hearing happens. And most of them are doing this almost as a pro bono. A lot of them are very successful attorneys who make $400 to $600 an hour, and they're doing the court-appointed attorney work for $75 an hour. If you're in Orange County, it's the public defender that represents a child. If you're in Riverside County, it's one law firm that they appoint to basically represent every child. But in San Diego County, it's a list of, 100, 200 attorneys that do that work. Okay, next slide. Okay. And just so you know, my goal in every conservatorship is no defects. And that I usually get that, but that's really hard to do. That's why I work 15 hours a day. So it's very hard to get it perfect every time. But if you do, it's always easier to get it right than to file supplements and everything else and have your court go back to court a second time. Also, just a little bit of information. All of the hearings have been online since COVID happened. The courts were shut down for about 3 or 4 months, and then they started opening up all remotely. So in most cases, you can still go to court, but you have the option to appear just like we're appearing tonight remotely. So you in San Diego County, it's on Microsoft Teams. In Orange County, it's on Zoom. And then in Riverside County, it is a call-in only. But you can call in through Zoom or just on that phone. But you could be in your pajamas. You're just on the phone. So that's kind of nice thing about Riverside County. But anyway, so we always had a lot of children who were immune deficient, and that was difficult for the parents to take them into that courtroom with millions of germs and millions of people that pass through that courtroom every courthouse every year, and that's all gone away. And for the attorneys like me, I didn't really like it necessarily in the beginning. I like going to the courthouses, but it's really nice now. It's a time saver like you can't believe. You're not driving there, you're not parking, you're not paying to park, you're not waiting to go up the elevator. You know, all that's gone. You just turn it on 5 minutes before your hearing and check in, and that's it. And then right after your hearing, you're done and you're back to working. So, okay, so alternatives, again, if your child is over the age of 18 and they can understand a durable power of attorney and healthcare directive, say they're Asperger's or high functioning autism, then I would look at those two documents. Sometimes people also seek conservatorship, but they don't ask for all the powers. Maybe the child want to have the power to fix their resident. That's decide where they're going to live. But the thing is, I always have the parents kind of, say, okay, that's fine. You can still have that power, but then, keep a power that they need, like medical. Most of those parents still always need the right to make medical decisions for their child. Okay, next slide. Thank you. Okay, so where is your conservatorship hearing brought, or your case brought? It's where the child lives. So if you're a divorced couple and the child lives primarily with mom and mom's in Orange County, then the case would be brought in Orange County because that's where the child lives primarily. So it's based on your zip code. And in Riverside, there are three different, there's Palm Springs, old downtown Riverside, and then Temecula. So there are three courthouses, and it's based on your zip code where you are. In Orange County and San Diego County, there's only one courthouse for the entire county. And so the conservatorship is, after your hearing, it's a lifelong process. So it's there to protect your child for the rest of his or her life. And so they send out an investigator every other year to make sure that, they're cared for, that they have the best and most appropriate placement and level of care. Okay, next slide. Thank you. Okay, so conservatorship is, just to back up again, it's a little confusing because in some states, in California, sorry, let me back up. It's guardianship of a person under the age of 18 and conservatorship of a person over the age of 18. So that's why we say you need a guardianship agreement because your child's under the age of 18. But in some states, conservatorship of an adult is called guardianship. So that's why people get really confused about what it is, or they hear about guardianship, but it's of an adult. But that's what we have in California. So there's two main types of conservatorship: general conservatorship and limited conservatorship. So general conservatorship in California is for a person who has dementia, Parkinson's, Alzheimer's, and things like that. They can't manage their assets. It's all going to be stolen, and they need someone to protect them from that. So, and then limited conservatorships are for persons who are a client of the regional center or not. Just a person with a developmental disability will still have to file limited conservatorship. So the limited conservatorship just spells out kind of the same all powers that you would get under a general conservatorship, but you can't file. So if you have a child with autism, you cannot file for a general conservatorship in any county. They'll throw it back out and make you refile as a limited. And then next slide, please. Thank you. So they're also within the conservatorship of the person and conservatorship of the estate. So conservatorship of the person, you have to establish the adult's incapacitated, they have developmental disability, and it began before the age of 25. Conservatorship of the estate is the same, but they have $5,000 or more in assets. So most of the families that I meet, have been to a lot of parent group meetings and they're educated about the $2,000 number. So your child cannot get means tested public benefits like Medi-Cal and IHSS or SSI once they turn 18 if they have more than $2,000 in assets. So it's a good idea to just not have your child have any money in their name. Don't have a bank account with $10,000 for sure, but just maybe have an account for them for $200 if for some reason you want to teach them to manage a bank account or something like that. But if you have to always have $2,000 or less, you're never going to need conservatorship of the estate. And just like that daughter who has to pay, $5,000 or $6,000 a year every single year for the accountings, you don't want conservatorship of the estate. It's very, very expensive. So without needing all of that, because your child doesn't have any money in their name, you probably are just going to need a limited conservatorship of the person. So next slide, thank you. Okay, and next slide. Okay, and then you can just scroll to these, please. So they're client the regional center. They don't have more than $2,000, so you don't need conservatorship of the estate. You don't want to pay for those accountings, believe me. And then that's what you need. So next slide. Thank you. And so what does the court decide? So first they decide this person who's an adult over the age of 18 is incapacitated. And then whether or not the persons who petitioned to be named conservators are the most appropriate persons to be named. And then up to the 7 powers that the court can grant. So they take away from your child and give to mom and dad, if that's the case. And then the court also decides whether or not the person retains their right to vote. The threshold to vote changed dramatically on January 1st, 2016. So it used to be, can a person understand an affidavit of voter registration? Those are the forms that we all filled out at the DMV so that we, could vote in that county or in that state if you moved into California or any other state. But that was pretty tough for them to be able to, most persons with autism to understand that. But the threshold changed. Now it is, can the person with reasonable accommodations express a desire to participate in the voting process? And so that's most people, unless a very severe person. And then there are courts that never take their right to vote away. And then there are court judges and courtrooms that do take their right away if they're not able to express that desire. So, okay, next slide. Thank you. The other thing is the judge and the court is never giving your child the right to vote. So all of us, everyone in the United States who's a legal citizen obtains the right to vote based on age and, citizenship, not based on capacity. So that was a case that went to the Supreme Court in the 1800s, a seminal case that decided, from the smartest person to the person who has the least intelligence, everyone has the same right to vote as soon as they turn 18. Okay, so you setting up a special needs trust avoids, hopefully it's clear to you, it's late at night, I know, that if you have a special needs trust, you're never going to need that conservatorship of the estate because your child won't inherit in their own name and they won't need an estate and all that accounting and court and everything. So it saves thousands and thousands and thousands and thousands of dollars during their lifetimes. Okay, next slide. Okay, so the things that you consider, hopefully take away if your child can't work and earn a living for themselves, and so that they'll need to be on means tested public benefits, then never have them have more than $2,000 in countable assets. You can look up online what is counted as a countable resource under Social Security Administration rules, and cash, a lot of things like that. But there are a lot of things that are excluded. They can own an automobile and things like that. If you have $166,000 or you own a home, if you own a home in California, you need a trust. You need a living trust to avoid probate. But if you don't, then you can just have a will and a special needs trust. So, And then establish the trust during your lifetimes so that, someone else will be able to safeguard your child's inheritance and make sure they don't lose their means tested public benefits, have a guardianship agreement in place. I didn't present about ABLE Act. That's kind of another presentation, but an ABLE Act account, best use of that is for persons who are working. And in California, they don't have to have payback provisions. That was a last minute add-on that we got. But in other states, the ABLE Act accounts have to have payback provisions. So they're kind of like a first party special needs trust. But they are very restrictive. Your child can only spend the money on what Congress decides they can spend the money on. You have to keep books and records. So it's not like debit card you give your child and you never know where the money went. You have to keep perfect records of that money was only spent on money that was allowed during the under the terms of the ABLE Act, passed under federal law. So an ABLE Act account is a 529A. Most people are pretty aware of 529C's, college savings accounts for minors. So, and then determine probably by the age of 16 whether or not you would seek conservatorship or maybe try the alternatives if your child is high functioning, or not. And then, look for an attorney or decide to do it yourself and start to investigate that route. So do I have another slide, Eric, or is that the last one? There you go. Okay, we're done. Thank you for listening. I hope I'm not been too confusing. I just got off a very long day and a red eye and things like that. So
I
I'm a little
know.
tired.
Thank you.
Thank you so much. Yeah, definitely. This is amazing. And I know you worked with us and just an amazing learning process to go through, and really appreciate what you did. I mean, definitely gave us peace of mind.
Oh.
So couldn't recommend you enough. And then coming here and sharing the information, because there's so much critical information to making wise decisions with this. That's, really, really big deal. So we appreciate that.